Some workplaces are enforcing their own vaccine mandates by placing their employees on unpaid leave or terminating their employment altogether if they refuse to get vaccinated without a medical exemption. Now, it remains to be seen just how many wrongful dismissal claims will be launched and whether they will stand up to legal scrutiny. I want to welcome in employment lawyer Alex Lucifero now to talk more about this. Alex, we've touched on this a couple of times. For anyone who hasn't seen, let's first of all go over what qualifies as a wrongful dismissal.
Sure. Well, it's an often used term in the employment law world. It's an often misunderstood term when it comes to employees. A lot of employees who are let go, when they hear the term wrongful dismissal, they automatically assume that they have been terminated for the wrong reason, that there was something wrong about their termination. And that's actually not the concept, Max. The only thing typically wrong about a dismissal is the severance that has been offered or perhaps not offered to an employee. So it's not really the reason behind the termination that is analyzed when it comes to wrongful dismissals. It's whether or not the employee has been offered the correct amount of severance. And oftentimes, I mean, most of the time, even employees that are offered severance packages are offered inadequate severance. And so wrongful dismissals are actually quite common, but again, it's not necessarily what employees always think they are.
Right, and again, trying to go through all this as we talk about it, specifically to COVID-19, let's talk about protocols, shall we? Can employers terminate employees for refusal to adhere to some of those protocols? So coming into work sick, not wearing masks, et cetera.
Sure. Well, yeah, I mean, following up on the point I just made, and an employee can always let an employee go. So even if it's a very minor infraction with respect to a COVID-19 protocol or really any other issue, there doesn't even really have to be a reason for an employer to terminate an employee. That termination can still be legal. The question, of course, becomes whether that employee, let's say if there is an infraction, whether or not they're owed severance in a case like that.
Right. And again, it's always talking about the level of severance and where it lands. Can I ask you too lately about these legal cases? We talk about it standing up in court, and I know there's maybe been a few of them, but have you seen any more going to court? Do we have any precedent yet of where the courts are going to land on this?
In the non-unionized sector, we don't, Matt. Those cases are gradually making their way through the court process, but we don't have any kind of decisions yet. We do have some arbitration decisions in the union setting, although it should be made clear that's not applicable to non-unionized employees. And the last point I would make on this issue is in the vast majority of cases, even if there is a minor breach or if there is a minor issue with respect to maintaining health COVID protocols in the workplace, those employees would still be owed severance. Terminating an employee without severance is effectively the capital punishment of the employment relationship. And so there would need to be a severe breach there for an employee to not receive severance.
Right. Again, always it's good perspective no matter what. Alex Lucifero, thank you for this, sir. Appreciate it as always.